Well, welcome everyone. My name is Dave Kubikian. I'm one of the attorneys at the Herzog Law Firm. We have offices in Albany and Kingston, Clifton Park, and Saratoga Springs. So up and down the Hudson Valley and the North Country and the greater capital region. And we do this. We do estate planning and we do elder law. And we usually do seminars in person so we could see faces and eat cookies and coffee at hotels and so on. Obviously, since March 15th, we haven't done any of them. I miss them. I miss you. I miss seeing people. I miss seeing confused faces when I go too fast. And I miss feedback if I do a corny joke and so on. But it is what it is, better safe than sorry. We have been able to continue to do what we do, which is help people with their estate planning and their elder law. And we'll talk a little bit about what all that means. But we've been able to do it in a very safe way. We've done lots of Zoom consultations and phone consults. I've had document signings in parking lots. That's, April, May, June, that's how we were doing things. Slowly, we allowed people to come back in the office with certain precautions. And now we're doing in-person meetings and signings again. But, it's November 18th and the news ain't so good. So we'll see how long we continue to do that. The good news, though, is that we're going to be able to get things done even if we're not in person. The governor of New York has allowed attorneys, and this really works for us incredibly well, to notarize signatures through video, as well as to witness things like wills through video. And that becomes really important because when the dust settles on all this COVID stuff, a lot of time will have gone by. And, if we have some long-term care needs, if we're applying for Medicaid, if unfortunately people pass away, no one's going to care that it was difficult to get things signed. They're going to say, did you get things signed when you needed to? They're going to say, have you gone through the 5-year look back period in the case of Medicaid in a nursing home situation? And they're not really going to care about the excuse, well, there was a pandemic going on. So it is really important that we could still get our documents signed. So what you see here on your slides here is estate planning in prime time. When I do my most general of estate planning and elder law seminars, it's this one. It goes from basic estate plans, wills, powers of attorney, healthcare proxies, through some fun TV family trees to help everyone understand what it means to have a will, what it means to not have a will. And then we get into trusts, avoiding something called probate, and then into long-term care planning. And I'm more than happy to go through all of these slides. It's a little more than an hour, probably an hour 15 the way I do it. However, this is a question and answer seminar at its heart. So if you do have questions, whether it's on topic, off topic, obviously if it's, you're asking me about my thoughts on the upcoming NBA draft, that's probably not something I should opine on, but I'm talking about if it's out of order when it comes to estate planning or elder law. I did have some emails that asked questions, and I will make sure to address those as well. Where they fit in on these slides are in certain spots, so I guess maybe I'll just wait for those spots. And as I mentioned earlier, you guys can all unmute yourselves, and if you feel like you could shout out something nice, or a question, that's also nice. Those would be great, and that can really lead our discussion. There's about 22 of us here. So, that's a pretty decent sized seminar, but it could be as specific as you want it to be. All right, so let's get going here. Basics of estate planning. If you said to me, what's the most basic estate plan anyone should ever have, it is these 3 documents: a power of attorney, a healthcare proxy and living will, and then something called a last will and testament. When it comes to a power of attorney, the idea is we're naming people on a sunny day. We're naming people today for a rainy day, metaphorically speaking, in actual legalese, right? We're naming agents who can transact for us, they could sign for us, and when they do sign for us, it is like we are there, right? If I'm power of attorney for my mother, and I'm talking to you in my capacity as power of attorney, it's like you're talking to my mom. I might not drag on the conversation as long as maybe my mom would. Love you, Mom. But the point is that actually you should check if she's logged on. But the idea is that we can do a whole lot of heavy lifting. It's as if that person's still here. And it becomes most important when mom is incapacitated, when mom is going through dementia, when mom's out of town and unable to transact or in the hospital, because I can move heaven and earth for her. After all, she's my mom. So why not? But legally, I could do that as well. And it's really important for spouses to have it for one another. A lot of times people think they can already sign for their spouse. Not true. Well, wait a minute, hold on. If I want to write a check, I could write a check. So can my wife. That's true. It's because both of you are on the account and either one of you has check writing privileges. That doesn't mean you are actually signing for each other. You're signing for yourself as a co-owner. There's a difference. So the reason why I think this is the traditional basic estate plan, power of attorney, healthcare, proxy, living will, is because at any point, bad things can happen to us, and we may, at 18 years or older, need help with a power of attorney, need help with a healthcare proxy, which is for medical decision making. A living will is for end of medical decision making, right? End of life kinds of decisions. Not so nice to talk about on cold sunny day. But they're terribly important because if we don't have a power of attorney, if we don't have a healthcare proxy and living will, and decisions need to be made, things need to be signed, bills need to be paid, we need to do something called a guardianship proceeding with the Supreme Court, which is a lower level court in your county. And in that court, we're going to be asking the court to take away your rights and give them to someone else, right? Take away my mom's powers, give them to me. The end result is I now can transact for her and she can no longer transact for herself. That's not very fun. If we do a power of attorney, the person giving the powers doesn't lose any powers. Of course, my mom can still do what my mom wants to do. I also can do it, and my job specifically, follow her instructions. She's incapacitated, do what's in her best interests. The last piece of the basic estate plan is called a last will and testament. And it is one of the most misunderstood documents. You could read it and say, oh no, I understand it perfectly fine. I don't need some law degree. A will says that I'm going to get personal property, and a will says that eventually, I'm going to split with my siblings, whatever assets my parents have. Wrong. That's wrong. And the reason why that's wrong is because, well, sure, it could be right, but in a lot of fact patterns, that's not the way wills work. At its heart, it's a document that says where your things are going to go. There's someone you can name as an executor to make sure those things happen, those rules happen. I give everything to my kids, well, the executor is going to make sure everything did go to your kids. It's not just like any other document, although you'll see sometimes commercials for getting your legal documents and estate plan done online. I don't think so. It's too important, okay, and there's too much that gets lost in the mix. I've seen it. It provides a good stream of income for firms like mine when it comes to estate litigation when clients do their wills online. The reason why I can say with confidence that a will is not the way all the assets are going to pass is because it's really, really hard in life to have all your assets pass through the will. So often we have things called non-probate property. What non-probate property is are assets that pass by operation of law. I have life insurance. I should. I have 2 little kids. I have life insurance. My beneficiary is my wife. If I did a new will leaving everything to the 22 of you that are watching right now, and then I die right in front of you in dramatic fashion on a Zoom, no less, you don't need to start spending that money. You will not get my life insurance money because even if my will says everything to you, everything does not include my life insurance. My life insurance has a beneficiary, beneficiaries control, and by something called operation of law and a death certificate, for me, that money will belong to my wife. Lots of things are like that, folks, right? Retirement accounts have beneficiaries. Brokerage accounts have beneficiaries. Stocks have beneficiaries. CDs and savings bonds can have beneficiaries, can be transfer on death, TOD, pay on death, POD. in trust for ITF, bank accounts, right? Not a lot of things are, not a lot of things have such an easy ability to avoid probate. Real estate, right? My wife and I are co-titled on a piece of real estate. If I die, that real estate belongs to her. No deed is needed. That's also by operation of law. So, we got to be careful. It's a double-edged sword, because I'm going to talk a little bit about how I really want you to avoid something called probate. I really don't want a will to be the thing that gives assets to people. But the answer to it isn't just having non-probate assets. The answer isn't just having things that pass by operation of law. And that's because legal documents like wills do have a higher purpose beyond just where do things go. I'm going to get back to that in a second. We're going to spend 5 or 6 slides here, subject to your questions. No questions yet. What happens if there is no will? Okay, people say, I need to have a will. I agree. You know what? Everyone should have a will. I won't say need. Need's a strong word. I'll say everyone should have a will. I hope everyone doesn't use that will when they die. I hope you don't die for a really long time as well. But you should know why you need a will. And there is a set of laws out there, or statute, that says what happens to your assets if you don't have a will. It's called dying intestate, and there are intestacy statutes. And in general, what they say makes sense. It's not perfect. And certainly we've seen scenarios where it has a lot of unintended consequences. But in general, what happens is that, and there we go, we got the bunkers here. In general, if you die without a will, the statute that New York has, EPTL 4-1.1, will say, if you die without children and you die with a spouse, everything goes to your spouse. If you have no spouse and you have children, everything goes to your children. You don't have spouse, you don't have children, you don't have grandchildren, everything goes up to your parents. No parents, siblings, no siblings, nieces and nephews. No nieces and nephews, and below we go up to grandparents, maternal, paternal, and over to aunts and uncles, and then down and down, down. So it's not like the government's going to get your money. Certainly that's possible if our family tree is very barren. Far more likely, though, someone who you don't want is going to get all your money, or someone that isn't in a position to get it, right? If it ends up going to your kids and your kids are 2 and 7 years old, that's a problem. If it goes to your parents, we've had this happen at the firm. We've had long-standing clients who did lots of Medicaid planning, and then, you know what, they got old, and then eventually spouse died, and then mom is in a nursing home, and everything in terms of the plan, obviously those are all unfortunate things. It's life, things happen over time, but our plan was to save a boatload of money for mom. We did that as she's getting long-term care. Guess what? One of her daughters died, 3 daughters, one of them died. No kids, no spouse, no will. Where did everything go? Up to mom. Mom inherited money, and then we promptly lost half of that money to the nursing home. Okay, so it's important. Everyone should have a will, because stuff like that happens. But I don't think the will's the reason why I want assets to go to whoever you want assets to go to. I want there to be other documents in a perfect world that do that. To show you a different version of facts when we're talking about intestacy, let's talk about a scenario where we're survived by a spouse, like Edith Bunker, and we're survived by a child as well, like Gloria. And in All in the Family, I hope you guys remember this show. I grew up with some of the reruns. I didn't grow up with the show. I was a little too young. So with the Bunkers, All in the Family, right? Carroll O'Connor, who plays Archie Bunker, is an interesting fella. I think I know who he may have voted for in 2020 if he was still alive. Archie, if he dies without a will, does not have everything going to his wife, and that's not his call, right? The laws of intestacy in New York say, if you die without a will and you have a child and you have a spouse, about 1/2 goes to your spouse and the other half goes to your child or children. And in this case, I crossed out Archie here. If he dies, we have Edith receiving 50 grand plus 1/2 of the assets. That's about what it would be, with Gloria receiving the other half. What's wrong with this? It sounds about right? We have things going to family. Well, let me ask you guys, and feel free, I hear some people unmuted, so that means you guys need to respond to this question. How old were Archie and Edith Bunker during the show? So anyone want to yell out how old they think they are?
At least 65.
At least 65. You want to bet on it? According to the Google machine that I use, the Bunkers were in their early 50s.
Wow.
They don't, right? Exactly. So obviously a lot's changed in the 45 years since the show was on the air, and 50 isn't 50 anymore. I don't even think 65 is 50 these days. It might be 70 is 50, maybe even older. So what that means in my mind, right, if we just said Edith is alive right now at 50 years old, at 54 years old, right, if God forbid something happened to Archie, she's got a lot of life left. And I want that lot of life to not have half the money. I want it to have all the money. Now, you may say, well, Gloria is going to play ball, right? Loving daughter. She's going to give money to mom if mom needs it. But think about that, right? That statement. She's going to give her mother money when her mom needs it. I don't like that at all, right? Edith should have all the money, and then she could leave to Gloria whatever's left upon Edith's death. But worse than that, right? What happens if Gloria predeceases mom one day? Well, she may have a will, right? But if she doesn't have a will in New York, where would all of her assets go? Anyone?
To the state?
Her assets, if she died without a will and she had a spouse, means everything would go to Meathead, which wouldn't be very good. At least Archie would not be very happy about that. So real easy basic will or estate plan, everything to spouse. Spouse predeceases me, everything to children. Under no circumstances does anything go to Meathead. Something like that sounds good to me. Okay. Next family, a little more complicated. I appreciate you guys going down this path. This is a show that's very near and dear to me. I grew up with Growing Pains. I loved it. Pretty much seen every episode. So here we have a younger family, the Sievers. The patriarch is Alan Thicke, the late Alan Thicke, who plays Dr. Jason Seaver. He's married to a younger Edith Bunker named Maggie Seaver. They have 4 kids, 3 kids for most of the show. Then they add a baby to expand the plot lines, I suppose. What's the problem here? Well, same rules. If Dr. Jason Seaver died without a will, 1/2 or so goes to spouse, the other 1/2 goes to kids, right? 4/8 is 1/2. We have 4 kids that each get an eighth equals 4/8 equals 1/2. So obviously mom's got a lot more life than even Edith Bunker. So there's the same things I brought up before. But here, for the most part, we have minors, right? For the most of the show, these kids are kids. They're minors. They're 18 and under, 17 and under. I don't want them to have money, right? I want all the money to be for mom. And it's not because these kids are going to put Toys R Us back in business. That's not going to happen, right? Mom would likely be a custodian or a guardian for that money. But the thing is, these kids one day will turn 18. And when they do, they're going to be an adult on paper. And there's no more guardian for them. They're 18 years old. They're going to get the money, whatever it was, and they're going to do whatever they want with it. It's going to affect their financial eligibility for college. It's going to affect their decision whether to go to college, because they may get, 40 grand and think that was the highest amount of money they could ever imagine. They're 18 and they're going to be really, really popular. So good basic estate plan, everything to spouse. If spouse predeceases, everything to my issue, my children. And if that's the case, next paragraph, if anyone receives and they're under the age of blank, it's whatever you want it to be, hold it in trust as follows. And then we can have pages and pages of how money is going to be held for college, or money is going to be held for down payments on homes, and don't give it under any circumstances before age 25, or if they seem like they're relatively mature, you can give it to them at 22, whatever you want, right? Another family tree scenario, another fantastic 80s show, the Keatons. Everyone remembers Family Ties. We have Stephen and his wife Elsie, and they are the proud parents of Alex P. Keaton, Mallory, and Ben. And then later on, of course, they add Andrew. Excuse me, not Ben. It's I forget the other daughter's name. Anyway, the lesson here is about special needs. Michael J. Fox I think he was just interviewed the other day. He has Parkinson's. We know what Parkinson's means. We know what direction Parkinson's goes in, at least with the current medicines out there. A lot of times we have clients who have children who have special needs, and they, we see it in the client questionnaires, and someone will come in, they'll see 4 kids, and we talk about their estate plan, and they'll say something like, oh, we're going to leave things to the 3 of them. And I said, well, what about Alex? For my notes, was there a falling out? What's the deal here? Because my antennas are going up. We got to make sure that everything's done the right way. And they'll say something like, oh, Alex, no, we love Alex is great. We love Alex. No, Alex, he still lives with us. And, he's got some special needs. And so, we don't want him to receive money because it'll ruin the benefits he's getting. And I always thought that was a really weird way to show how much you love someone, by not leaving them any money and technically disinheriting them. And you don't have to do that. Just basic documents, whether it's in a will or a trust. I leave everything to my spouse. My spouse predeceases everything to my kids. If my kids are below the age of blank, hold it in trust, et cetera, et cetera, et cetera. Next paragraph. For Alex, any money that Alex receives will be held in trust as follows. And we sprinkle in some language that will make it so that money can be left for him. Perhaps Mallory will be in charge of that money. She can pay for this, pay for that, but she has no obligation to do so. He has no access to the money, and for all purposes, we are still allowing him to qualify for all those benefits out there. So, he should be left something, in my opinion. A better scenario, to be honest with you, is that mom and dad can create a trust today for him. So that way other family members can also, if they're inclined to leave things to Alex, instead of everyone having their own special needs trust set up for Alex in their documents, they could just say, I name Alex P. Keaton Special Needs Trust created by Stephen and Elsie, and however they want to describe it, as being the destination for some of their estate. So everything at least is being funneled to the right trust. A couple more here, and then we'll go on our way and talk about avoiding probate and so on. Here we got the Huxtables. I'll call them the Huxtables because I don't want to call them the Cosbys, because Cosby, right? But this is a fantastic show, number one. Number two, fantastic family tree for all things estate planning. I could probably spend an hour on this family tree. So we have a very affluent family. They lived in Brooklyn Heights. I lived in Brooklyn Heights. I went to law school at Brooklyn Law School, and that was in Brooklyn Heights. Really nice area. We have a doctor. We have an attorney. Claire was an attorney. And they have 5 kids, ranging from minors, Rudy and Vanessa, all the way to grown women in Sandra and Denise. Denise got married to Lieutenant Martin, who had a kid. Denise adopted Olivia. That's an important fact when it comes to estate planning. Sandra had twins with her husband, Elvin, et cetera, et cetera, et cetera. So everything we already talked about, right? Minors potentially receiving money. Grandkids potentially might receive money if their parents predeceased. What's important here is that, in the show, Elvin, Lieutenant Martin, they're the in-laws, the son-in-laws. I'm somebody's son-in-law. I'm a good guy, I promise. Not all son-in-laws are created equal. Not all daughters-in-law are created equal. We may like our daughters-in-law or our son-in-laws, but you know what? I don't know if I trust them entirely. If when my daughter gets married one day, if they have kids, my estate planning documents are not going to name my son-in-law as trustee for any money those grandkids would get. Instead, I would name my son as a trustee. Sometimes we're tempted to leave things to the adult in the room, or our son-in-law is going to get money, if not my daughter, because they have kids together. Well, son-in-laws can get remarried eventually if your daughter predeceases. I know it's really grim to think about, but this is what I do. And while we're doing these heavy-duty documents, a will, a trust, whatever, might as well take into account all these bad things that may happen in life. And for the most part, not always the case, but for the most part, people do like blood being in charge of blood. That also can blow up in our faces. I've seen that quite a bit as well. Every fact pattern is different, but in general, in-laws are in-laws. I'll leave it at that. Lastly, on the family trees, So here we have a lesson in guardianships for minors. The show Full House is all about a single father, Danny Tanner, raising 3 little girls with the help of his brother-in-law, Uncle Jesse, and his good friend who is called Uncle Joey. Now, only one of those uncles are real uncles, and that becomes a really important fact because if, God forbid, Danny Tanner passed away and those girls are minors, his will would name guardians for those girls. If he does not have a will, there's a good chance Uncle Jesse could be a guardian for those girls. There is a slim chance that Uncle Joey, a comedian from Canada, is going to be their guardian. The lesson here in general is, look, there are different people who are important in our kids' lives and in our lives. It's not always family. Lots of considerations to go into when it comes to guardians for kids. What area of the country would they be living in? Are they uprooted? Can my parents still take care of them? Et cetera, et cetera, et cetera. You need to have a will if you have a minor or if you have grandkids. You better make sure, I don't care what state your children live in, make sure they have wills because they can name guardians for their kids. It's incredibly important. So that way, if the worst happened, we at least, have a good, competent adult in the room who's ready, willing, and able to take over and be guardian for those kids. All right. So I convinced you should have a will. Congrats. Will should be done the right way, as I mentioned before. We need 2 disinterested witnesses signing the document. We need, you have to sign it at the end. You have to declare it to be your last will and testament. No written changes, et cetera, et cetera. And if all goes to plan, if the will is the big document we have, that will means nothing. Just a piece of paper. It means nothing until 2 things happen. Number 1, we die. And number 2, that will makes its way to surrogate's court in the county you resided in. So that way the state of New York and the county you resided in can say, yep, this in fact was a will that was signed the right way, and it is the official will of the person who passed away. What's so bad about that? Well, the high end of the filing fee to get in the door in court is $1,250. People like me get employed by representing estates and doing all this work. The process of administering an estate usually will be about a year and usually is at least 7 months after the will's been admitted for probate. People say, what's probate? Good question. Probate is the proving of the will. The word probate is to prove. It's the proving of the will. Not the will was a good idea, not the will makes sense, that the person who signed it did it knowing what they were doing in general. They had the capacity, no one was holding a gun to their head, etc. And then the court's going to make sure everything that was in the will happens in terms of who gets what. There might be an accounting at the end of it. It might be several $1,000s to do an estate administration. So you may want to avoid probate. Okay, basic estate plan, check, check, check. What's next to think about? It's avoiding probate. It's of course accumulating assets, because why not? I have nothing to do with that, but I thought that should be a goal. And then starting to plan for getting older and failing health and all that stuff. Right? The good news never lasts very long around here at Herzog Law Firm. So I want you to avoid that whole probate thing. I think it's a really big waste of time and money. But I still think probate makes sense in certain circumstances. Obviously, it would be unfortunate if it happened because it means that somebody passed away. But this is what I mean. There are ways to avoid probate. I mentioned all those things that could have beneficiaries. I mentioned all those things that can be jointly owned, right? Bank accounts could have transfer on death to so-and-so, right? Life insurance could have a beneficiary at death. Great. Well, you know what? Those beneficiary forms, you've seen them. You have accounts, you have life insurance, right? What do you do when you got to change your beneficiary on your life insurance or on a retirement account? You put in a name and a percentage, maybe 3 names, they're each getting a third, right? And then maybe you put backup beneficiaries, right? There's no room on those forms for rules as to when your grandkids are getting money, or what happens if this, or what happens in that. What happens to Alex P. Keaton? How do we leave him money the right way? And the most important thing to me for my clients, it's not to avoid probate, it's not to save them money, It's to make sure that at the end of the day, their money goes to whoever they want it to go to, the way they want it to go to them, right? Who gets what? When do they get it? How do they get it? And I compare this to getting a car wash. You could even to a car wash, right? You can get a regular car wash, it's cheaper, gets the job done. You can get a more deluxe car wash, more expensive, more protection, right? Some frills. You can get the super duper deluxe car wash with all, Armor All here and there, and then, more protection, more expensive. No matter what you choose, guys, what happens? The car gets washed, mission accomplished, right? There's a lot of different ways to get the car washed, right? You have those options. All of them end with the car getting washed. Is one better than the other? Well, in terms of just the basics, getting the thing clean at its basic level, right? Getting assets to the right people, it's all the same. But questions like how much money was left, right? I had a long-term care experience in a nursing home. I'm broke now. Well, yeah, everything is going to the same people, but there may not be as much left. So it's still really important to plan on that higher level. And we're going to talk about the whole rest of the webinar this way. But I want you to know the most important thing isn't saving money. It's not avoiding probate. It's getting the right things to the right people. And then once we're all square on that, and that is going to happen no matter what we do, all things are equal, then we start looking at, okay, how do we avoid probate? How do we maybe protect assets? So having beneficiaries on your assets, that's a great way to avoid probate. But usually, especially when life gets complicated, either because we have young kids or because we have old kids and grandkids and we're old ourselves and life gets complicated, those beneficiary designations may not be enough. They may not be the way you want to avoid probate. That gets us to trusts. So, everyone, I've been talking for a little bit. Does anyone have any questions? Is anyone still here? Is anyone awake? Anyone? Nothing? Can I hear breathing? Can someone let me know they're here? Good. I heard,
We're here.
Okay, good. Good. Very good. So let's start. Oh, we got a all okay. Thank you, Mike. Thanks for reporting in. So let's start talking about trusts. Okay. I'm not going to hopefully spend too long on the introduction to trust, but it does need an introduction. So there are a lot of different trusts out there. The two main kinds are testamentary trusts or inter vivos trusts. A testamentary trust is a trust that is in your last will and testament, thus testamentary trust. It makes sense. And all those things we talked about, right, with the different family trees here and leaving things for Alex P. Keaton or leaving things for these kids from Growing Pains. Those are, language in there. Leave everything to my kids, but not until age 25. Boom, testamentary trust, done, right? Obviously, you want more language in the will to make sure that everything connects, but great example of a testamentary trust. An inter vivos trust during life, right? Inter vivos during life, that takes a couple of varieties, and that's the types of trusts that help us avoid probate. The problem with testamentary trust is we got to get through that will to get to that trust language. We got to go through probate to get to the trust language, right? I mean, gets the car wash, right? But might be a better way to do it. With the inter vivos trust, we're creating it during our lives. And if I could use my Starbucks cup here as an example, this is a trust, right? You create it and you put stuff in it. You can take stuff out of it. The rules on how you put it in and how you take it out, that determines the kind of trust it is. We're going to talk about Medicaid trusts in a little bit. Funny thing about Medicaid trusts. Do you know what word? This is great. Do you know what word is not in your Medicaid trust? Any guesses?
Medicaid.
Medicaid is not in the Medicaid trust. It's not a Medicaid trust because, or called it that, it's a Medicaid trust because of the rules in it, the rules of how you put money in, how you take it out. That's what makes it a Medicaid trust. And when we start talking about Medicaid, that'll make sense. In terms of the inter vivos trusts, the two main kinds are, I'd say, are revocable and irrevocable. And here's where minds start to scramble, okay? This is the toughest part of my job is going through the differences in these two kinds of trusts, revocable, irrevocable. And the problem is with the English language, because the word irrevocable means something, but it connotes a lot of other things. So since we're all somewhat unmuted here, I'll ask whoever can hear me and respond. What does the word irrevocable mean? Go ahead. Let me hear some stuff, please.
Can't change it.
What's that?
Can't change it.
You can't change it. All right. What else? What does irrevocable mean? What else?
That's what I think.
So what I hear often is you can't change it, you can't control it, and you can't undo it. Right? Wrong, wrong, wrong. In fact, that's not what you know, or at least you can change it, you can control it, you can even undo it. But the problem is that when we talk about, well, what do you mean? Irrevocable. What irrevocable means, guys, you're going to throw stuff at me. Irrevocable means not revocable. That's literally what irrevocable means, not revocable. Okay? You can't figure out what something means by defining it as what it is not, right? To know what irrevocable means, we need to know what revocable means. So what does revocable mean? What revocable means is that you, I'm pointing at you by yourself, whenever you feel like it, can undo the thing that you created. The key in that, though, is you can do it by yourself. Revocable literally means that you by yourself, you alone can undo the thing you created. Irrevocable means not revocable. Revocable means you alone. Irrevocable means you can't do it alone. Doesn't mean you can't do it. It doesn't mean you can't control it. Doesn't mean you can't change it. You can do all those things. It just means technically you by yourself can't do it. Okay? And that's where there's so much confusion. Hopefully I'm changing some minds out there. So revocable trust is a trust you create. We put stuff in it. When things are in the revocable trust, the owner of that thing is the trust. We take your house that's in your name and we put it into your trust. The new owner of your house is the trust. Who pays the bills? You still do. Who gets the star exemptions? You still do, right? Who gets to live in the house? You still do. Everything is the same, right? If you put finances in there, you're still the income beneficiary of those assets. The big thing with revocable trusts is that it's a separate entity, which means that if I died tomorrow and my house is owned by the trust, my will isn't in charge of what happens to the house, because my will only governs what I owned when I died. And I just told you the trust owns the house, not me. So revocable is a great way to keep things out of your estate and avoid probate. But because it's a document, it's a trust that has rules as to where your money goes when you die, right? What happens when this trust ends? We can add all the language you talked about for growing pains and family ties and all of that, right? Who gets what, when do they get, how do they get? Remember the car wash, right? The car is going to get washed, but now we're using the revocable trust to wash the car. We're avoiding probate with it. What comes with that are, no filing fees and less legal fees. Sometimes attorneys are involved if there's some conflict, but it's far less than when we're doing a probate. It's private. You're your own trustee typically, and you'll name backup, someone to clean it all up when you're gone or you're incapacitated. But it's a great way to avoid probate. And we typically will see revocable trusts, when it comes to complicated family trees, second relationships, children from prior relationships, and so on. All right. That's revocable. Now, I had a good time with saying what irrevocable is and what revocable is. We're going to spend the rest of our time here, except for some of the questions I had, just talking about a specific kind of irrevocable. There are different irrevocable trusts out there. If you're Googling irrevocable, you're going to call me a liar because I made it seem like you have too much control. Well, for the Medicaid Asset Protection Trust, which we're going to talk about right now, which is technically irrevocable, I'm not lying. I'm absolutely telling the truth. And there, I would say, if there was such a thing, I would say that the Medicaid trust is barely irrevocable. It's irrevocable really for one purpose, and that's to protect assets from Medicaid. And as you'll see, and as we're kind of backtrack through it, Medicaid's very particular about how you can protect assets, and we're able to not only enjoy our assets and enjoy the income produced by our assets, and also have really good tax consequences, which is where some of the questions come in. But we're able to basically live like we have a revocable trust with one little exception, and protect our assets when it comes to long-term care. So long-term care, it's a thing, right? We're all going to get older. That's the plan. And as we do get older, older and older these days, we're going to develop needs. The only way we don't develop long-term care needs is if we die before those needs develop. Those needs can be very expensive, and the really between a rock and the hard place part of it is that these expenses will creep up when we no longer are earning money, right? We are on a fixed income, whatever our retirement's providing. So if all of a sudden we have a multi-$1,000 monthly obligation for long-term care, that really destroys our budgets, and it forces us to do nothing but spend down our assets along the way. In terms of financing for long-term care, private paying out of your pocket. That's what a lot of people do when they don't know they don't have to do it. Long-term care insurance is a great tool as part of the plan. And more often than not, people are going to turn to Medicaid as a way to pay for those needs. The default plan for most people is you're going to go through your money until you qualify for Medicaid. And the idea of planning is if we do a little bit of planning ahead of time, we don't have to go through that whole go through our money part. We could actually protect our money and leave nice inheritances for the next generation. Sometimes people will say things to me like, well, you know what, that doesn't sound very nice. I never thought I'd be on Medicaid and yada, yada, yada. Well, first of all, that's like an ego thing, okay? Medicaid is a huge program, and only a small piece of it is the part of Medicaid that most people usually think about in terms of, well, not having a lot of money. The Medicaid program for long-term care by design, right? This is not that difficult, guys. All you need to do is plan 5 years ahead of time, and you can protect your assets. It's not some sort of shady dealing. Literally, the law says all you got to do is plan 5 years ahead of time. If they had a problem with it, they'd say you can't qualify ever. But they say, here's your pathway, just plan. Okay, in 2006, all you have to do is plan 3 years ahead of time. Now it's 5 years. One day it'll be more, which just means you got to plan earlier, but it doesn't mean you can't plan. Of course you can plan. That's what the law says. What about Medicare? What about Medicare? Well, Medicare is health insurance for those 65 or older, and Medicare has a couple different parts to it. Medicare is health insurance. What's health insurance? Well, health insurance is paying for stuff that helps you get better, or preventative things that help you keeping from getting bad. Okay, that's the least scientific description of Medicare you've ever heard, right? Or healthcare. Healthcare is when you're getting better. And so Medicare can cover things like hospital visits and rehab. It can cover things like managed care, prescription drugs, doctors, right? No long-term care coverage though. And people all the time will say, well, wait a minute, I know a neighbor. That neighbor had a fall, that neighbor went to the hospital, that neighbor went to rehab, that neighbor came home, and Medicare covered all of it. So how dare you say Medicare doesn't provide long-term benefits? Well, that's a very lucky scenario, and that happens, and it's important to know about it. If you've been admitted to a hospital for 3 days, and then you go to rehab, Medicare can cover the first 20 days of rehab in full. They can cover the next 80 days of rehab with a rather sizable daily copay, which amounts to about $5,100 a month of copay, which is a lot of money. But yes, in the right fact pattern, Medicare can cover, and then you can go home and resume your normal life. That requires that you keep getting better through your rehab, because at some point, if you plateau in your recovery, Medicare says, aha, you're not getting better anymore. That's not healthcare anymore. This is long-term care. Go talk to Medicaid, go private pay, etc. Private paying is expensive. We got to change these slides because it's more like at least 13.5 or so for the monthly cost of the nursing home.
15.
Well, 15 is what happens a lot, but at least, right, there are a couple places that are 13.5. There's one in East Greenbush right now we're dealing with where I think it's around between 13 and 13.5. But it's a lot, all right? And most often your rule of thumb is going to be somewhere between 425 and 450 a day for skilled nursing in a nursing home. Average stay in a nursing home is about 2.5 years. That don't get me wrong, the average person does not need 2.5 years of a nursing home. The average person does not need a nursing home. Okay. But if you do, the average stay in a nursing home is 2.5 years. And the reason why I think is that more and more people go there because of cognitive stuff. They have healthy bodies and other things are failing them. So they need the nursing home, but they're going to be around. That heart's going to be ticking for quite a while. Private paying is a lot of money because 13, 14, 15 grand a month is a problem, and it'll go through assets relatively quickly. Long-term care insurance, great option. I am not a long-term care dealer. I understand it quite well. My parents have something called the New York State Partnership Plan. I'm proud of them for doing it. I'm happy they're not using my money to pay for it, but I'm happy they have it. It's a great form of a plan. Long-term care takes a bunch of different varieties, including hybrids that have riders where we have death benefits and long-term care benefits. I know a bunch of fantastic long-term care insurance guys and gals. If you need some names, kick the tires on them, do your due diligence. Okay. The important part of long-term care for purposes of today is if you do have it, you need to know what's in it. What coverage is it? What's my elimination period? The amount of time I need to go through before the coverage actually will start paying, right? I have an event, then I trigger my policy, elimination period, 90 days, 100 days, right? What does that mean for me? How do I come up with money those 100 days, et cetera? All important questions for you to know. People think you got to have long-term care insurance or you got to do a Medicaid trust. Baloney. They work very well together. Usually lower limit long-term care insurance coupled with Medicaid, I think is a fine plan. Okay. I'm happy to give my opinion later on or in private on your specific fact pattern and whether this is a good option for you. But I am, as I mentioned, not a long-term care provider. Finally, Medicaid. And just bear with me a second. I'm going to take a look at one of the questions I had because it was a good one. Let's see where we're at here. Joyce. Okay. No, it's a little too early for Joyce's question. Hi, Joyce. How are you? All right. Let's talk about Medicaid here. So Medicaid, it's like Medicare, except nothing like Medicare. It shares 6 letters and it confuses people. People say, I'm here for a Medicare trust. I say, no, you're not. Sometimes they say, well, I already have Medicaid. I say, no, you don't. They get confused all the time. Medicaid, long-term care, Medicare, healthcare. Medicare, getting better. Medicaid, plateauing. Okay. Federal program. Each state has a Medicaid program. Each state's Medicaid program is supposed to have a home care program as well as a nursing home program. Some are better than others. New York happens to have a really, really good home care program. Medicaid is not just something you qualify for because you turned a certain age. It's something you qualify for because you turned a certain age and you're below the thresholds that Medicaid has. What are said thresholds? Not a lot, okay? When it comes to nursing home levels, which is different than the care at home, the community Medicaid levels, nursing homes, right? Single individual, grandpa needs a nursing home. He can have just under $16,000 of resources. He could keep a whopping $50 a month. What about grandma? Grandma's doing all right. Well, she could have about 75 grand of resources. Her income could be 3,200 a month. Well, what happens if grandma's income's just Social Security, but grandpa had the pension? Well, then we can move money from grandpa over to grandma, get her up to that level, et cetera, et cetera. There is a 5-year look-back period for nursing home Medicaid, and the idea behind the look-back period and what Medicaid cares about is incredibly important. This is the fundamentals here, guys. Number one, Medicaid steps in your shoes. When we apply for Medicaid for someone, we will provide 5 years of everything to the county. And what the county is looking for is they're looking for what things you, by yourself, that's key, with just your signature, what you can get, what you can access, what money you can have at your fingertips. Because they say, well, if you can get the money at your fingertips with just your signature, well, why don't you sign, get some money at your fingertips, pay the nursing home, and call us when you're out of money. Valid point, Medicaid, valid point. So what they do is they step in your shoes. If you could get it, they can get it. Now, they're not going to get it. They're not going to take your money. Most people think they're going to take it. They do not take your money. They simply say you don't qualify, and then you take your own money and you give it to the nursing home, okay? Same difference. So they step in your shoes. If you could touch it, they could touch it. So what are resources, right? Things like bank accounts, CDs, cash, savings bonds, stocks, brokerage accounts, life insurance with a cash value, your real estate, because you could sell it, jointly held assets that you can get to, things in your revocable trust, guys. Why? Because revocable trust, you, the creator, by yourself, just your signature, and pull everything out. So the revocable trust, great for probate avoidance, not great for long-term care planning. It's too easy. You have too much control. When it comes to retirement, the rules are a little different. Qualified retirement plans are exempt, except for Roth IRAs. They're exempt. You got $2 million in your IRA. Guess what? That's not going to keep you from qualifying for the program. The income rules will be applied to the distributions you get from that retirement. However, as a resource, as an asset, no, we're good. All right. So what do? Right? We want to avoid probate. We want to plan for this thing. This is 5-year look back period. We have a hand raised. I don't know what that means. We have a raised hand. Go ahead and ask your question. Or
Yeah, so what you're saying is they're going to look at how much money you get in Social Security. They're going to look at how much money you get from a pension. And they're going to look at whatever monies you have in your bank account. So everything you have, they're going to take a look at.
Yes, that's right. They're going to look at everything. They're going to categorize things as an asset or as income. Those bank accounts are an asset. They want to make sure you don't have more than about $16,000 of assets. But the things that are tied to retirements, they're going to say that's income, Social Security, pensions, required distributions from your retirement accounts. And the way it works, I don't know if there are a lot of sport fans out there, but it's like the assets are a salary cap. You can't have more. You do not qualify. If you have $1 more, you don't qualify for the program that month because your assets are too high. It's really a hard cap, a hard line. On income, they say, well, obviously everyone's got more than $50 of income each month. You can qualify with your pension and your Social Security and your required distributions from your retirement. However, depending on the rules and whether there's a spouse and how we budget things, you will essentially have a deductible every month, a spend down. You're going to have to spend down your extra income each month. Now, big picture, $15,000 a month nursing home, and we end up spending $4,000 a month in the form of our income, and that's all we have to give. That's a pretty good deal, right? We saved $11,000 a month in perpetuity, and our assets are protected if we planned ahead of time. So even though the income rules certainly aren't great, they're actually a lot better than nothing because it won't keep us from qualifying for the program. It just will keep us from retaining lots of income. Those spousal rules become really important. The difference between home care and nursing home care becomes really important because in a home care situation, we can actually protect all the money. Thank you for your question. So what this leads us to, we know what resources are. We know they're going to look at income as well. We know revocable trusts don't cut it. So how can we prepare ahead of time? And is it worth it to prepare ahead of time? Okay, great questions I asked myself, but they're good questions. So to understand how we plan, all right, I just want to go back and look at how this look back period works, because this is also really misunderstood. And then Joyce, I'm going to get to your questions because they're very good. Okay. One day, hopefully not one day, but it may happen, we're going to meet with you or a family member about you. And we're going to talk about how we need to apply for Medicaid, for home care, or for nursing home care. Both have a look back period. Home care right now is a 2.5-year look back period that's being phased in. Nursing homes have a 5-year look back period. And we know what that means, right? If we're going to apply to Medicaid on November 18th, 2020, we're going to give them records going all the way back to November 18th of 2015. Right? The world was a lot different there in many, 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 many different ways, right? But 5 years, we're going to provide all that paperwork. And they're going to look to see whether you've gotten rid of your money and how you got rid of your money. They're going to look to see if you gave money away and where you put it, okay? And what they have the right to do during this look back period is aggregate all of those transfers you made that were gifts and penalize you for it, because that's not very fair. You just got rid of all your money in the form of a gift, okay? That's what they're looking for. And there are certain exemptions to it. They're kind of hard to get to, but there's, they're not looking in terms of what you gave to your spouse, because again, both spouses' assets and income will be looked at in the Medicaid application. So let's say I need a nursing home. We're applying now. We provide 5 years of look back, and look at that. It turns out over the 5 years, about $100,000 was moved out of my name in the form of gifts. And you may say to yourself, well, that's a lot of gifting, right? I wish someone gave me $100 grand over that time. It could be because you set up a trust, okay? Because those are technically gifts. It could be because you did something called a life estate deed on your house in favor of your kids. It could be because, one of the kids is going through a tough time and you're trying to be a good parent. They're going through a divorce. You're helping them out, right? A lot of different just run-of-the-mill regular types of things where 100 grand over 5 years may not be as big as you think. But let's just say it's 100 grand. What Medicaid does is they apply something called a regional rate to determine what the penalty period is for your transgressions. The regional rate depends on your region, and it's about $11,000 in the capital region. We take that and we divide $100,000 by $11,000 rate. What we get is the answer is about 9, which is a 9-month penalty period. 100,000 divided by 11,000 is about 9 months, about 9. What that means is for the next 9 months, you need to be in a nursing home, otherwise be qualified for Medicaid, and then going forward 9 months, pay your own way in that place. It's a really punitive penalty, okay? It leads us to why the trust is the right way to plan, okay? Because we don't know if we're ever going to need a nursing home. We don't know, what 3 years from now looks like, or 2 years from now. I don't know what January 20th looks like, okay? I'm a little concerned. So I don't know. We don't know the future. So what do? Right? This penalty applies only when we're already in a nursing home. It's going to be punitive because over the next 9 months, when I, by definition, have less than $15,000 because I'm qualified for the program subject to this penalty, I got to come up with 15 grand a month, right? Doesn't seem very fair to me. Well, what we would do in that type of situation where someone hadn't planned ahead of time, or we didn't get through 5 years, is we do some version of crisis planning to try to save 50 cents of every dollar. I'm going to skip this for a second and go to the trust, because how and when and why you prepare for long-term care gets me always to this idea of doing a Medicaid trust, the Medicaid Asset Protection Trust, that thing that's kind of somewhat irrevocable. And here's the deal. This is kind of how it works. And Joyce, we're getting to it. Medicaid cares about when you by yourself can get to your money. They care about the things that are in your name. They care about the revocable trust that you can touch whenever you feel like it. So all we got to do, folks, is create a trust where you by yourself can't get to your money. That's it. That's all we got to do. And that's what this trust is. I don't mean to simplify it, but that's kind of pretty simple. We create something where you can undo it with the help of another signature, which means you by yourself can't do it, right? Medicaid cares if you could by yourself do it. We make it so you by yourself can't do it. Well, who do we need? Whoever you want. Whoever you want, right? Typically, we want our trustee of the trust and our beneficiaries of the trust in order to pull our own principal out of the trust when we feel like it. Now, I told you before, right? People think irrevocable means you can't change something, you can't undo something, you can't control it. And I said, wrong, wrong, wrong. Well, if we need other people to do things, how do we still control it? Well, the way you still control it is in this trust, you still have the ability, look at that bottom bullet point down here, right? You still have the right by yourself, the revocable right, to amend your trust, to fire your trustee and replace them with whoever you want, to amend your trust, to change your beneficiaries to whoever you want. The fact is you always control whose signature you need when you want to get to your own money, okay? So you still control it. It's just this one little extra red, thing of red tape. It's the whole point is to save a boatload of money, right? That's why we're doing it. But why does the trust make sense? Because we get this all the time, right? You're gonna spend $3, $4, $5,000 on a trust and related documents. I could just give money to my kids, right? They promise to give it back to me if I need to undo it, if I need a nursing home in the next 5 years, right? My plan didn't work. Well, if you think having a trust where you control all the moving pieces doesn't mean control, giving money to your kids really doesn't need control, right? Bad things happen to kids, right? Kids die, kids get sued, kids go through divorces, kids go through bankruptcies, kids put additions on their home and say, Mom, don't worry. When you get old, you can stay with me. And then you get old and then kids say, sorry, Mom, you can't stay with me. The point is, I need you when you're preparing to still control things, including be able to undo everything to, because we didn't get through 5 years, undo everything so I can do this thing called crisis planning that saves about 50 cents of every dollar. I'm not going to get into it because we're already an hour in. I haven't even gotten to Joyce's questions, for crying out loud. Which brings me to Joyce's questions. Joyce asked, in an irrevocable trust, will the beneficiaries still have a step up in the value of property and stocks that they inherit? Very good question, Joyce. So here's the deal, guys. If I died right now, if you died right now, you know what, forget me. If you guys died right now, okay, whoever your beneficiaries are of your assets, they're going to get those assets as if they bought it today for purposes of taxes, for purposes of capital gains. So if I bought a share of Apple for $1, now it's worth $800. That means if I sold that share for $800, I would make a profit of $799, and there would be taxes on that $799, capital gains taxes. When I die, if I own the shares in my name and I gave them to you, you receive them with what's called a step up in the tax basis. You, in your pocket for tax purposes, own it as if you bought it for $800, which means if the next day after I die, you sold it for $800, there are no taxes. You sold it for $800, you bought it for $800. For me, I sold it for $800, I bought it for $1. I have taxes I have to pay. The idea of this step up in the tax basis is tied to you during your life still enjoying the asset, right? Having use and enjoyment of it. When it comes to things like stock, like Apple, right? I get the dividends, I still owned it. It's part of my estate for estate tax purposes. Most people, have more than $11 million, have less than $1 million, $11 million, excuse me. They don't have estate tax liability federally, so they don't need to worry about it, but they'll end up getting what's called the step up in the tax basis. The trust still has you as the income beneficiary of the trust, still has you as using and enjoying your property. You're still paying all the bills. Life's kind of all the same. And most importantly, everything in your trust is subject to estate taxes, whether or not you have any estate taxes you need to pay. Most people don't, which means we all end up getting a free step up in the tax basis. And yes, this trust maintains that step up. This doesn't create the step up. You don't need this trust to get it. This trust is something that protects your money while keeping the step up intact. Number two, do IRAs need to be liquidated before you can qualify for Medicaid coverage if you go into a nursing home? No, they're exempt as a resource, but Medicaid's going to want a little piece in the form of those required minimum distributions each year. Hopefully that helps. Tom asked a very good question. Thank you, Tom, for this. Well, what happens if we gave money and then there's this penalty period and, well, we don't have enough money to pay for the nursing home because we just gave away our money and we can't get it back? And that's when people start playing the violin, because it's such a sad story. Yeah, you're not going to be able to stay in a nursing home, right? It's going to be a really, really bad situation because you can't just give away your money and then qualify. The reason why I love this trust more than any other reason is because you still control it and can undo it. Nothing's safe until we get through that 5 years. And because there's no guarantees, I need to make sure you can undo it. More importantly, guys, I need to make sure your power of attorney agent, because that document's so important, allows and can sign for you to undo the trust and put money back in your name. So I can do that crisis plan that could save about half the money, not all the money, but half the money. Okay, very good question, Tom. Thank you for that. So the Medicaid trust, right? The idea is we can still open up the box and pull money out, right? We can still do it, but it's not just our own signature. We don't own the key. We just happen to control who's got the keys. I call it a box with 3 locks because typically it's yourselves, the trustee, and the beneficiaries who need to all agree when we're pulling money out. You control who the trustee is, you control who the beneficiaries are, you always control who's got those other 2 keys. And in my mind, that's control. Okay. One part I didn't really talk about, there's whole seminars on our website, www.herzagala.com, that you can go to. The blog page has a bunch of these webinar videos, just like this one will be posted, all about aging in place, the idea of getting long-term care benefits in the comfort of your own home or an apartment or your kid's home or what have you. No look back period as of October 1st. It's not October 1st no more. There is a 2.5-year look back period being phased in. Roughly speaking, they're going back to October 1st in terms of qualification. Yet to be seen how the penalty periods will work in that landscape. We do Medicaid applications, even though I think we're really great at everything else that we do in terms of estate planning, Medicaid planning, these trusts. I do honestly believe the thing that we do the best, bar none, is Medicaid applications, because we are extremely creative in using Medicaid rules in ways to save even more money and really take advantage of whatever fact patterns presented. We're professional lemonade makers because we're handed lots of lemons, and that's what we do. So if a loved one is going to need long-term care now or in the future, home or otherwise, it's always worth a conversation to see what we can and can't do. Always, guys, the best thing you could do is prepare ahead of time. That doesn't mean you need a trust, right? In fact, I should have said this at the beginning of the seminar. You can't come to one of my seminars and leave thinking you need, well, you may leave thinking you need an Advil. You may leave thinking that I had too much coffee. You may think a lot of things, but you shouldn't be thinking I need a trust or I need this or I need that, other than I need to hear more about it. I need my specific fact pattern to be looked at by Dave, Debbie, Jane Marie, Harry, whoever, another law firm, okay, whatever. This is for information purposes. A lot of this is all things being equal. Things are never all equal. The facts all matter. There are so many nuanced points on the Medicaid in particular. There are loopholes, maybe isn't the wrong word. There are exceptions. There are exceptions in the law that you may qualify for, and it's important to know what all the details are. We're at 3:15 here, right? We're at 1 hour and 15 minutes in. Any other, we learned yesterday about community Medicaid, 30-month look back. It may be January Is that sure? Okay. So there has been a change. Tom mentioned a change to the community Medicaid program where there is no look back period if you applied prior to October 1st. And now it appears that there, well, not appears, there is a look back period. If we apply for community Medicaid right now, they're not looking for 2.5 years worth of paperwork to justify that application. What we've heard from the counties, they're going to be looking for documentation back to October 1st. What's been unclear to us is how the penalty period will work, because in the case of a nursing home, right, no matter if you need a lot of care or a little bit of care in the nursing home has a certain rate for that room, right? And that's what you're going to pay, and that's how we could justify the penalty. For home care, right, we can't just tie it to a length of time because not everyone needs the same amount of care. The cost of care is dependent on the amount of hours you qualify for. So there's a lot of gray area as to how that's going to be taken care of by Medicaid. So what, that you were over-resourced, you had more money than you were allowed to have on October 1st. What does that actually mean? I don't think there's any attorney out there who could tell you with certainty what it all means, other than, you know what, it's a pandemic. I don't know what the next 4 or 5 months look like. I don't know if Medicaid says, hey, you know what, we picked the wrong time to implement this. The new date we care about is April 1st. I don't know if that's going to happen. And so my general rule of thumb, and I tie this to a quote or paraphrase a quote from When Harry Met Sally. This is my new thing to quote here. I'm sure you've seen the movie. There's a line towards the end of it that says something along the lines of, I came here because when you realize you want to spend the rest of your life with someone, you want the rest of your life to start as soon as possible, or something like that. How does that relate to Medicaid planning? Well, as soon as you realize that the right thing to do is a trust or to plan in general, you want to plan as soon as possible. Not because something bad's going to happen, because something might happen that's bad. I'm not saying plan now because they're going to change some effective date for community Medicaid. I'm saying plan now because they might. And if they don't, we got 2.5 years of look back to accrue. Okay, so get going on it. And the get going, what I mean by that is get in our office, get in someone's office that knows what they're talking about, and let's go through your fact pattern to see if a trust makes sense or not. We do free consults. That's a good segue. Phone, Zoom, in person, what have you. A couple home calls every now and then. We're on the radio on Saturday mornings at 8 a.m. to 9 a.m. It's replayed the following day in the upper Hudson Valley, Kingston area. And you can hear us on Magic 590 or 100.5 FM in the capital region. In the North Country, 96.9 FM and 1410. I hope you guys got a lot out of this. Not as many questions as I was hoping, but thank you for joining us. As I mentioned, this thing here is going to be posted on our website. Feel free to share it or review it again. Oh, slides will be sent around to everyone. We do have one more question. Go ahead with your question.
Okay, I'm a little confused. You mentioned that qualified retirement plans are exempt. What is considered a qualified retirement plan? Good
question. So I don't have a definition for it, but I'll give you examples of them. So a 401k, a 403b, an IRA, a pension plan, anything like that. The only exception to it is a Roth IRA. A Roth IRA is funded with after-tax dollars. It's not, the growth is tax-free. And for that reason, I believe they consider a Roth IRA to be a resource. Where this comes into play is that sometimes people come in and they say, I have an annuity. Okay, well, your IRA can own an annuity. I have a CD. Okay, well, your IRA can own a CD. And the question is, when it comes to assets, is this asset part of a qualified retirement plan or is it not? The things that are not qualified, the things that are not part of a qualified retirement plan, like a regular CD, right? That's a resource that is part of the $15,750 you're allowed to have. Okay, so that goes against that number. Whereas a CD owned by a qualified retirement plan, that principal amount of that CD will be exempt because it's part of that qualified retirement plan, but then Medicaid will look at the income that should be generated by that qualified retirement plan. Does that make sense?
Okay, so one more question. So
Yeah.
if you have a state or federal pension, that's considered a qualified retirement plan. Is that
Right,
correct?
so that's income. The value of that plan is the income it's providing, and they'll look at that plan only as a source of income. And they'll apply the income rules to that, which is good. I mean, the income rules are problematic in general because, in general, Medicaid doesn't want you to keep a lot of income. But for home care, there's ways to protect all your income. For nursing homes, right, we're stuck only keeping $50 a month. So we'll lose that pension. But we'll do it in the name of getting a $14,000, $15,000 a month room for far less.
Okay.
All right.
So
Guys,
one more
yes,
thing.
go ahead.
Okay,
Yes, please.
so that 15,750, are you talking about per month or per year?
Per month.
Love to have.
No, the 15,750 is the total amount of assets you could have. Total amount of resources you're allowed to have total, right? You apply for Medicaid with 20 grand in the bank, you don't qualify because that's more than $15,750.
Okay, but I'm saying, is this on a monthly basis or a yearly basis?
When you apply for Medicaid, they want to know what you got. And in order to qualify, those resources need to equal less than $15,750. It's a snapshot. So at the moment we're applying. And then because they have the 5-year look back period, they press rewind to see how you got down to that amount. So we don't apply for Medicaid for someone unless we know their resources are what they're allowed to be. Because otherwise we're just wasting time. We're going to get a letter that says you're over-resourced, you don't qualify. So it's a
Gotcha.
snapshot at the time we apply. I don't want anyone sitting around here and putting everything they got in trust and leaving themselves with money just in case they need a nursing home. That's going to be crazy to me. So what we want to do is protect large amounts, big things that would go through probate, like a house, right? And then as life changes, as we're not doing as hot, over time, we would want to move more and more into the trust to slowly start to protect things. So that way, one day when we do apply, snapshot, what we got is $15,750, or we got down there. And we could do things like prepay funeral expenses to get down there. You could pay nice people like me for our Medicaid services. There's lots of different ways to spend down money, but my goal isn't going to be to save every dollar because you won't want to live that way. The goal is going to be to protect a lot of money, have the ability to unprotect it and put it in my pocket again, or go on trips when we're allowed to go on trips and all that stuff, right? To have options. And the way you have options is by protecting things first and then always being able to pull things out.
Beautiful. Thank you.
What I'd love all you guys to do is feel free to email us, info@herzoglaw.com, or I think you probably have my email from registering, dkubikian@herzoglaw.com, with any questions. I'm one of 4 attorneys that primarily do estate planning and elder law. Jane Marie Schaefer, Debbie Verney, Harry Miller. We're all very experienced, and we'd all love an opportunity to talk to you or your family about whatever's going on in your lives. So thank you so much for joining us again. We're going to try to get slides around. It might take a day or two, and obviously get the videos up there. Have a wonderful, wonderful rest of your day. Take care.
Thank you very much.